once again to my channel. My name is Msime Tarex, and basically today want to again appreciate one of the important areas in contract law 1, and that is a privity of a contract. Want to unpack the privity of a contract. We have a video on the privity, but now we want to basically look at the exception to that doctrine. But of course, even before we look at the doctrine, it is important that I give you a bit of recap regarding that doctrine. But still, even before we look at the doctrine, we must also appreciate what is a contract. A contract is defined under Section 9, subsection 1 of Contract Act as an agreement made with free consent of the parties with capacity to contract with the lawful object for lawful consideration and with an intention to create legal relations. It is important to know that a contract can be made orally or can be made in writing, and it is also important to know that a contract that exceeds 25 currency points must be in writing. That's a must. That's the general a contract that exceeds 25 currency points must be in writing. Okay, so of course then now we move to the doctrine of privity of a contract. As a whole recap, the doctrine of privity of a contract is basically a common law doctrine which holds that a person cannot enforce a contract if that person was not a party to that contract, or if that person is not actually a party to that contract. So that it means basically that only parties to a contract can enforce it. That is the doctrine of privity of a contract. It has been heard in several decisions right from England under common law, and just like common law is the law applicable in Uganda pursuant to Section 14 of the Judicature Act. So when you look at cases of Tweedle versus Atkinson, in Tweedle versus Atkinson, they refer to the jurisprudence in the case of Prince versus Easton, hold that if you're not a party to the contract, you cannot enforce that contract. Okay, that is actually what they held. I'm giving you a bit of recap. Then you look at cases of Dunlop versus Selfridge. That is one of the Rocas Classics cases regarding the doctrine of privity of a contract. You look at it, then I encourage you to also check with the Yuri and see and get those decisions. There are many decisions in Uganda where the same principle has been held. So now let's now drive to the main topic of today, which is the exceptions to the doctrine of privity of a contract. What are the exceptions? Because I mentioned earlier in the other video that the doctrine is not absolute. And when we say that the doctrine is not absolute, it means there are instances where the doctrine is set aside and we proceed to enforce the contract, yet you are the side party. Okay, that is very, very important. Of course, and the exception number 1 being agency. An agency here is where a person is working as an agent of another person. For example, the good example we have is the MTN agents. When a person is working as an agent of MTN, if that person enters into an agreement with the client or the customer, and anything happens with regard to that agreement, so that client, who is now a third party, can enforce the contract immediately against the MTN company. That is what it means. It means we are setting aside a principle in Tweedle versus Atkinson. We are saying that no, at this point in time, this person has the capacity, because you are trading with an agent. As you know, there is a principle under contract law that he who acts through an agent acts for himself. So that is it. He who acts through an agent acts for himself. So agency is one of the best examples for exception to the doctrine of privity of a contract. Okay, so of course another exception, the one more exception, is what we call assignment. And assignment is another good example where a person assigns another one to do something. For example, let's say I sell you my car and you are supposed to pay me tomorrow, but today I'm not in position to come, so I assign someone to the rights to come and pick that car. So that means he has all the rights to come and enforce the contract, to come and pick my money, or to come and pick my car, because the person who entered into a contract has assigned that person with the rights. Okay, that is very, very important for us to understand. So an assignment is one of the best examples where a person can enforce, where a third party can actually enforce rights, can actually enforce a contract even when he was not a party to that contract. Okay, so it is important for you to really appreciate. Then another good example is what we call third party rights. And third party rights, this now takes us to vehicles. For example, if I have a third party insurance with a certain company, a certain insurance company, so if my vehicle gets into an accident, the victim can sue the insurance company, the company that gave me an insurance policy. Okay, that is very, very important. So that is another good example that maybe we may need to understand so much. And then we have what we call negotiable instruments. Negotiable instruments, or what we call bills of exchange. Under bills of exchange, here we have the best example is the check. I want to explain this by giving you live examples, the key examples that we may need for purposes of appreciating it the more. You look at an example like if I issue a check to someone to go maybe get money from Centenary Bank, but the money I indicate on the check is higher than actually the amount on the bank, so that there is a likelihood actually the check has to be bounced, but you can still withhold it for purposes of preventing fraud and stuff. So it means the bank, yes, it was not a party to the contract as to why I gave you the check, but it can come now to sue, to inquire why a check that was issued indicated amount higher than that one on the bank account. That is how it works. Bills of exchange. I issue the receipt, I issue the check, but the amount it indicates is higher than, so they can hold the drawer accountable. The person who issued, the person who drew that receipt. That is very, very important. But of course, that one is governed by what we call a Bill of Exchange Act of Uganda. The entire law governing that is known as the Bill of Exchange. That is for purposes of Uganda. But for those outside Uganda, of course, you may have your own national laws that regards that. You need to find out, you need to check with your universities or with your authorities to know what are the laws that govern that kind of an exception. Then we also have constructive trusts. It is also another good example where a person can enforce a trust even when he was not a party to creation of that trust. Okay, that is very, very important. But of course, we have very, very many exceptions. I encourage you to take time as you do your research, get to understand more and more and more of these exceptions. They are very, very many. You may get like 15, but of course, we cannot give you all. We must leave you with an opportunity to do more research. But here we come to explain so that we get the basics and to guide us in our usual research. But of course, I really encourage you and thank you so much for watching the tutorial session. I encourage you to subscribe. I encourage you to share with friends and leave a comment where you find it necessary. Otherwise, God bless you. I wish you well in your journey at law school.